render unto us a message from the CEO of the Uganda Society, who is in this spot. Ladies and gentlemen, Ms.
Thank you, Robert. Good morning, ladies and gentlemen. The Vice President of Uganda Society, Mr. Anthony Asimo, the CEO of NASCNET Uganda, Dr. Sylvia Mukasa, Sports Consultant and Proprietor Haman Pedro, Mr. Henry Anderson, and Mr. Gabriel Achayo, who is joining us online from the East African Law Society, the council members who are present here with us physically and those online, our esteemed members of the Uganda Law Society, ladies and gentlemen, I bring you all greetings from our CEO, who is currently unable to join us because of another prior commitment, but she sends you her warm regards. On behalf of the CEO and on behalf of our Radical President, Mr. Isaac Semakade, Senior Counsel, and the Governing Council, I welcome you all to this 40th weekly session of the R&B Live Series, which, as you know, is the brainchild of the Radical River President, and as mentioned, it's the 40th going for quite a while. We really value your time that you spend with us here each week as we deliver topical issues during this press and public engagement. And so today we reflect on some of the important and timely things. In the MC mentioned them, but I will repeat them. The first one being the state of access to justice in Uganda, making a case for the Access to Justice run that is scheduled to happen, I think, on 29th November. The guests will speak further into it. And one of the people that will speak into it is Mukasa. The other is promoting corporate wellness, and this will be to discuss managing non-communicable diseases through paid sport, and this will be done by the sports consultant and proprietor of the non-pedal, who is Mr. Henry Anderson. Yeah, and then Mr. Gabriel Achaye, who is joining us online, will take us through the 30th East African Law Society annual conference at the end of November this year. So I'd like to thank you all for being part of it. Encourage us to continue to raise the bar as we move forward with the Radical River. For this note, I would invite our Vice President to give us the opening remarks. Thank you.
Thank you, Sheila. I'm not only for mentioning me, but we're standing for who we know is not well. And with the entire secretariat team for holding fort. Distinguished guests today, Dr. Sylvia Mukasa and your team from NASCNET, Mr. Henry Anderson, alongside my friend Roman, who I'm sure has come with you today. Mr. Gabriel Achaye, I'm sure you're joining us online. The council members who I'm sure are following online, because not of them are here, members of the bar joining us, secretariat staff, the fourth estate, ladies and gentlemen, good morning to you all. I do bring you greetings from the Radical Governing Council, being they are with you in spirit, as much as they're not here physically. They do say their own regards specifically, and most importantly, the President, Isaac Semakade, he says regards people today. As you heard Robert mentioning, and as you can see, this is our 40th R&B session. When we came into council, in a bid to execute our mandate to ensure we remain relevant to not only the members of the society, but also members of the public and the government, we came up with this R&B Live event weekly, where we, for the past 39 weeks, have had these engagements on a weekly basis, and usually you have engagements with the public, issues affecting rule of law, human rights, and individual and personal well-being. We've had several of them. It's been fantastic. It's been a journey, and this would not have really been a success without the support from the secretariat team. And every time we have an event, you have noticed that it is because of the significance of that particular aspect that we tend to have an engagement. We tend to air it out and have and share with the public. You may also have the biggest number of people online because one of our 4Ds is digital transformation. We believe people should access this information and services from the comfort of their offices, their homes, or whether they do not have to move here physically. And I appreciate a few of you who manage to make it here physically and listening and see what's happening. That doesn't mean we do not appreciate the members who take time to join online and engage with us. Now this week, like Shiziko and Robert has three major topics for discussion for today. The state of affairs in Uganda, making a case for the access to justice run 2025. In a special way, allow me first congratulate the Lord Movement Center, legal aid clinic that celebrated 25 years of offering legal aid. And I believe it is something most of us got involved in. Yesterday we had a march and a legal aid open day. It is not something we take for granted that there are people in this area of pushing for access to justice for every Ugandan, making sure access to justice is a reality, and sticking to principle despite the challenges, especially financial. And I believe Dr. Sylvia is better placed to speak about this from her position because of her passion to access to justice. And I believe that's what I believe will be clear from her presentation. The need for these services, legal aid services. Here at Uganda Society, through the legal aid project, we do offer legal aid services across the country, and we know what it takes. We walk this journey. Again, the challenges that on the way, the challenges we've gone through. And we also have experiences that we can share. But most importantly, we do appreciate of Dr. Sylvia for thinking about coming up with such an event, the Access to Justice Run, which is a sign of intentionality and purpose that has been attributed to access to justice. It's a good cause, and without really waiting for the presentation, I do call upon the members of the bar, even the members of the public, to join us. I'm sure I shall get the details on how it's going to be done, but I know it's a good cause. It's something that requires each and every citizen's participation because it's a right. It's something each and every one of us deserves. It doesn't matter the status, it doesn't matter where you come from, the rich or the poor, all of us have a right to access justice from wherever we are. So I do thank you, Dr. and your team, for coming up with this initiative. And I do believe that the journey you're taking, which you stuck to all these years, is the right direction, especially in the fact that it also aligns with the mandate of the Uganda Society under Section 3 of our Act, which is to assist the family regarding all matters that was considered to the law. So we do appreciate you and we welcome you today. The second topic that focuses on promoting corporate wellness, managing non-community diseases through the sport. As you may be aware, most of us, the practitioners, spend so many hours seated in offices, in courtrooms, reading, even British officers. And in the recent past, we have how some people have dropped dead because of these health conditions that come due to the nature of the work we do. And the biggest mistake some people have always made is paying less attention to your health, to your well-being, both mental and physical. And again, I believe this is an opportunity for us, the members of the bar, to see this, trying to So if you cannot get along, then that means the family goes, as to suffer. We very few of our members, open the shop, sell items, sell the service, which is to your head. And if you at any one point are not able to perform the tasks you perform, you're not able to get out of your bed or else to go and work, then at the end of the day, that is the end of you. We've had members before where they get into some health complications, where carrying out car washes to raise some money, and because if any lawyer spends a month or two without working, I can assure you, even the clients you have will walk away and look for other lawyers who can be available. So I feel this is very important to promote wellness as members of the bar, to focus on that. I've in the past received some calls from even some young members of the bar who have been asking how are we being intentional in ensuring that at least we promote the well-being of the members. How are we convening members? Because everyone can do that wherever they are. But the fact that Mr. Henrik, you've accepted to join us today and give members an opportunity to hear about, the best way to do it. We do not take that for granted. And I encourage all the members to pay attention to this. And please make sure you pick it up and embrace this because it's for your own benefit. Now, thirdly, I believe Gabriel Acha is with us online. Gabriel is not just a colleague from the ELS, he's one of us. What he does and about the Uganda Society. We'll come to hear from you to talk about the East African Law Society, why we are members, and we are all aware that come November we have the 30th ELS conference, which I think will be in Addis Ababa, and we do call upon members to take part, to register and attend because these regional bar associations and meetings benefit us in growing our business, in networking, and it's an opportunity for members here to go and see what other colleagues in other jurisdictions are doing, how they are managing practice, how they are doing business, and also the opportunities for partnerships. There are people who would want to come here and do business, legal business, and they want to know if they can partner with here. So it's really such a big opportunity. And I believe Gabriel will give us more insights on what will be happening on the 26th and the 29th of November 2025 in Addis Ababa, Ethiopia. The reason we are members to some of these, organizations, even regional bar associations and international bar associations, is not just for being a member, but to benefit the membership of the society in professional growth as well as business growth. So, Gabriel, you're welcome, and thank you for being there for the illness every time we call upon you. I remember you gave us a lot of support during the take. You brought your experience from the East Africa, from that perspective, and we don't take it for granted that you do spare your time again to be with us. So, colleagues, I once again, on behalf of the Governing Council, welcome you. I'm personally excited to see how this unfolds because everything we have today is really interesting and exciting. I might have a bit of an idea on a few of them, but I call upon you to pay attention, engage, listening, and also let's take action from what we get from the team today. I once again welcome you and I wish you the best of the day. Thank you.
Thank you very much. Thank you so much, the most perpendicular Vice President and the heartbeat of the Radical Yoba. We want to thank you for your very awesome remarks and the insights you gave us. We also appreciate you as an individual. I call him Robocop. For those who were able to watch some of those movies, he never tires. He's everywhere and he is like a rebel, like he says. Thank you so much, Mr. Vice President. And with all those that has been said, we want to take the chance to start the day into listening to different distinguished speakers. And we're not going to go so far without listening in. We're going to listen to an advocate of the High Court that and is also the Chief Executive Officer of LastNet, who holds a master's degree in development studies majoring in human rights and social justice perspective from Erasmus University in the Netherlands. She holds a diploma in legal practice and an LLB from Makerere University, along with an honorary doctorate in humanity from Zoe Theological University in the United States of America. She has served as an ED of the Uganda Law Society and headed its legal aid and pro bono services. She also has been a magistrate, an external examiner in family practice at the Law Development Center. She has also been a very resourceful person on access to justice and child-friendly justice. Her leadership roles include membership to the Judiciary's Case Management Committee and various subcommittees, the State-Funded Legal Representation Committee, and serving as president of the Sacred Heart Schools alumni. She is also a member of the East African Law Society's Rule of Law Committee, the Advisory Committee for Legal Aid at Uganda Law Society, and the Justice Committee of J-Laws. She is a recognized member of FIDA Uganda, the Uganda Law Society, and the East Africa Law Society. She was listed in the Courtroom Mail, 100 African female lawyers in 2022, and was acknowledged for her contributions to access to justice for vulnerable persons in Uganda by the National Association for Women Judges in 2019, among others. Ladies and gentlemen, with that illustrious introduction, allow me to welcome Dr. Sophia.
Thank you so much, Director of the Day, the program, for that kind of introduction. I'm really happy to be back home. This is one of the areas where I have served and I always cherish. And I'm glad this far we have come. Congratulations to the Council and the Secretariat for this enormous work and innovations. The Vice President of the Uganda Law Society, Radical Member, and the council members, the governing councils, the capacities, wherever you are listening in and tuned in. Fellow panelists in your respective capacities, the Secretariat, distinguished members of the bar, the general public, ladies and gentlemen, a very good morning. I take this opportunity to appreciate the Uganda Law Society for giving us this platform to be part of the 40th R&B Live Service. Thank you for giving us this opportunity. Before I start, I'd like to introduce the team I moved with. Yes, I was seated there with none other than Ms. Flavia Mokoya, the Deputy Executive Director of IRAF, Human Rights Forum for Human Rights. It sometimes runs out of my head. IRAF, Human Rights Promotion, yes. And she's the chairperson of the organizing committee of the Access to Justice Run, but also Organizational Development and Sustainability Committee of LastNet. So that is the lady I moved with that is leading the team that is organizing the Access to Justice. I also moved with the Director of Programs, Badwal Sansa Omlangira, at the Uganda, I don't know, forgive when I keep on confusing, eh? You know the history of the Uganda Society and now, that's it. Yes, Badwal Sansa is the Director of Programs and he's also the coordinator of the Access to Justice. I moved to the in-house council. I am the Dennis. Yes, in charge of the pre-rehabilitation of the project of LastNet, but also the in-house council. I moved in the lobby and advocacy, Ms. Justice Namboa of LastNet. And I also moved in working coordination and partnership officer, which I'm taking. So that is the team. I'll be making the presentation, but in between there, I'll be calling in the director to expound more on the Access to Justice run. And then all the questions that will be coming in answered collectively when we are ready by now. Thank you. Today the topic I'm speaking about is access to justice. The state of access to justice in Uganda, making the case for access to justice run. That is the topic that is so passionate and dear to my heart. Because almost 20 years of my service, I've been in access to justice, programming, addressing issues, firefighting here and there. And so access to justice refers to the ability of to obtain just resolutions and decisions, justify problems, and enforce their rights in compliance with human rights standards. There exists a myriad of international and regional policy framework that underpin access to justice, which Uganda is a state party. We have the Constitution, we have the UCPR, we have the conventions in their different perspectives. But today, allow me to speak about one of the decisions in the Kenya Omwansa, George, and another versus Attorney General. It is a Kenyan law report that defines access to justice includes the enshrinement of rights in the law, awareness of and understanding of the law, is the availability of information pertinent to one's rights, equal rights, the protection of those rights by the law enforcement agencies, is the access to justice system, particularly formal adjudicatory processes, availability of physical legal infrastructure, affordability of legal services, provision of a conducive environment within the judicial system, expeditious disposal of cases and enforcement of judicial decisions without delay. That is the cocktail of access to justice. And once that is not there, then you cannot say we have access to justice. If the law offers rights and entitlements, the rights holders are aware of their rights. There is a prevalence of access mechanisms to enforce and protect the right through legal and judicial services in a timely manner and fair manner. Thus, remedies plus remedies, as well as the ability to enforce the remedy, then we say we have access to justice. Access to justice envisages the ability of people to effectively access, navigate the legal system, and seek remedies and resolve disputes through formal and informal justice. But we have to remember that it also has to have conformity with human rights standards. So that when I make conditions to access justice for clarity, we have to make sure that the existence of the legal framework, we have the laws in place. Not only having laws in place, there has to be wide legal awareness and literacy among the population, because it's not enough to have the laws when the users don't know where to go to do and what to do. But also, they have to have affordability and the quality of legal advice and representation is part of the access to justice. Availability of dispute resolution mechanisms is part of access to justice. Availability of efficient and impartial methods. Availability of efficient and impartial methods. So if the methods are there but they're not efficient, if there is partiality, then you cannot say there is access to justice. So the two words that we have to go with when we are discussing access to justice is accessibility, affordability, and availability, whether in a formal or informal justice. Sorry, I'm having echoes. The United Nations requires all state parties to commit to providing access to justice for all, recognizing it as a key indicator of peaceful and inclusive societies with an aim of combating discriminative practices in achieving access to basic services. So access to justice, the way we have healthcare, the way we have education, the way we have roads, is the same importance the states are supposed to put or equate to access to justice. I've heard this being said several times, especially when we are pushing for the video. It's not a priority. We don't have resources, and that can wait. But access to justice cannot wait, because it's the cornerstone of any democratic governance. It's the cornerstone of accountability. It's the cornerstone of transformation. It's the cornerstone of rule of law, justice, and peace. So if someone is uncomfortable with what is happening around them concerning their right to access justice, they are being displaced on the land, their property rights are being abused, their child neglect, the administration of estate issues, one can never have peace, even if they have a road where to pass. So I would like at this juncture to mention and to emphasize that access to justice is as important as we need what we call kits for women in the hospitals, as we need roads where to pass. We need to also pay attention to the access to justice issues. And that now brings me to the discussion of the state of access to justice in Uganda. Uganda's justice system has evolved over time, supported by the establishment of frontline institutions, including Ministry of Justice and Constitutional Affairs, also law. Remember I told you about the systems and infrastructure, police, Directorate of Public Prosecution, prisons, Uganda Law Society, Uganda Human Rights Commission, and many more that form the justice law and order sector. These institutions, as they deliver services, are complemented by other justice actors, including civil society, non-government organizations, media, among others. The National Development Plan 4 encompasses two broad programs aimed at enhancing access to justice. That is the Governance and Security Program and the Administration of Justice Program. Formerly, the Governance and Security Program was the Justice and Order sector. And now, under the Administration of the Justice Act, introduces the Administration of Justice Program. To this end, We have had progressive legislations such as the Administration of Justice Act that I've told you, and others. The importance of the Administration of the Justice Act is that it has significantly empowered the judiciary to become self-accounting and autonomous in dispensing of justice. We have had other improvements, like now the operationalization of the state brief scheme, including the enactment of the practice rules known as the judicature legal representation at the expense of the state. Rule 22 now puts into place legal aid and also helps to ensure that the those charged with act offences are implemented. And it also puts in place the monitoring structure, which is the committee. Again, the judiciary has made commendable steps and progress through innovations, physical and technological infrastructure. We now have the IKIMIS, and it can't go unnoticed. And when we're speaking about digitalization, it has strengthened and improved access to justice. But also, we have infrastructure, state-of-the-art Supreme Court buildings, Court of Appeal, and across the country, when you read the various reports, they keep on giving us the progress in terms of construction of justice centers. There are also innovations that I need to speak about, like bottlenecks mediations intended to expedite justice, small claims, allowing litigants that cannot be represented by lawyers to go to court, plea bargaining, fast-tracking the criminal justice system, ADR to ensure that we also bring in the informal justice dispute mechanisms, and promoting people-centered justice. All have contributed positively to the judicial transformation agenda. Currently, and most importantly, the judiciary has launched the Judicial Performance Enhancement Tool, which was launched on the 17th of October. This tool is giving an opportunity for the performance of judicial officers to be appraised internally and externally. So that is very important because it is giving accountability, and we are able to give our views on how the judiciary is performing at individual. However, and notwithstanding the above, the following issues remain outstanding when it comes to access to justice. And I want to give you some statistics. According to the Justice Needs Survey 2016, 80% of Ugandans are vulnerable, and they cannot afford the services of private lawyers. Less than 5% of dispute resolution take place in courts of law. 40 million Ugandans, as at 2016, get the 4%, and those are the people that we are going to reform upon. And we are having less than 1% of their cases resolved. So those of you who understand mathematics, calculate the magnitude of disputes arising and what is resolved annually as of 2016. The subsequent civil justice needs 2024. They noted a slight percentage increase in formal courts from 5% to 10%. They also documented the most prevalent issues, or what we call the justice needs of the people of Uganda, with majority having land disputes, land wrangles that form different facets. There are land wrangles that get into the category of the haves, those that grab, those that have assets, but also there are land wrangles within the countryside of the most vulnerable, those that are being evicted. The family disputes, and you will have to be lawyers, especially in family practice, you visit the land division of the High Court of Uganda, and you are only in Kampala. The corridors are full. Land disputes have increased. Domestic violence, and some of the domestic violence cases are never reported. And especially poverty-driven crimes. I am deliberate by saying poverty-driven crimes. If you go to the prisons, majority of the people in prisons are facing charges that we call minor offenses, not felonies. And some of those that have felonies, They are again emerging issues related to economic things or issues. I will not elaborate, but the lawyers know the cases we find day to day when they go to courts. The dispensation of access to justice is currently riddled with perceived and real corruption. When you say there is corruption, they will tell you it is perceived. But between me and you, that interface in the corridors of the judiciary, the corridors of police, the corridors of Office of the Director of Public Prosecution, you know how every day people are parting with money to get justice. The bond which says is free is never free. And also that we know that most of the litigants participate in these transactions as givers of the bribery or not. But the people we already, I told you 80% are poor. Those are the people we are draining as we are making them access justice. So it is very difficult to obtain favorable outcomes, as I told you, that can be accepted when the system has been oiled. For the vulnerable persons we serve, the perception remains that justice is for the rich, or as long as you don't have money, you can live. And this has eroded the public interest, the public trust in the judicial system. When Afro-Parliament does its survey, it will always tell you there's no trust in the justice system. Erosion of judicial independence, because we know that there is interference at different levels, whether political, whether by the powers that be, and as a result, the outcomes are always not out as expected. Prison congestion. Many prisoners, especially the youth, are in incarceration because they don't have money. The average case of a criminal case of the felony is 5 years. And don't forget that when they cross mandatory period of remand these days, it's very hard to get because of the revision of the bail guidelines, very hard to access this, what we call automatic bail. At my time when I was a judicial officer, and I need to speak about it, I served at Uganda Road, one of the most busiest courts. But whenever these people come, especially those who have no representation and they have crossed the mandatory period of remand, whether capital offense was, you had no option but to release at their own right. You give a bond because the prosecution has failed. This is no longer the case. Papers have to be falsified and they have to be assessed by the court and the judge. And all that time people are on demand. Because there has been slight improvement in the convicts. But the majority are on demand. And we have a research of the youth justice needs. You will find that the majority are youth and their time is running out. By the time they come out, they are adults. They don't know where to start from. And all they will do is to repeat that repeated offending or recidivism. And they get back because they find prison to be their home. At the prison, they will do gardening, they will be fed, they will be teachers, if they know if they are teachers, they will do carpentry. So the prison gives them a much better life than the outside. The access to justice in Uganda is also marred by human rights violations of pre-trial rights aspects. We have witnessed habitual arrests, we have witnessed enforced disappearances, and we've seen detention without trial. And it has not been uncommon in Uganda, especially during the elections. And now we're already in the period of elections. And before we used to have the legal rapid response by the Uganda Law Society, by the NetField, by LastNet, but currently we don't have more resources, so many are going to languish in prison. I've already talked about the limited trust in the formal justice system remains high. influenced by sometimes the mob justice. Some people prefer more the formal justice. If you go, you will find in many traditional leaders, religious leaders, RTCs, among others, they are resolving disputes and quickly so. Now with land disputes, people prefer to go to RTC. Because they know they will pull out their what? Will. Their voice speaks with power. So they will find themselves going to RTC to resolve disputes. But again, that dispute remains hanging balance. There are certain disputes that have to come within the concourse, whether we like it or not. And there are disputes that can go for formal and quickly be resolved. Lack of legal representation to hold the poor and vulnerable while they access services. Like I've said, only 20% of Ugandans, according to the Hill report of 2016, can access services of private practitioners. They are the ones who can afford to pay the 10% legal fees. 20% of Ugandans. We don't have a state-funded legal scheme, and all efforts to push for it has been taken. Legal aid is mainly provided by non-state actors, apart from the state brief scheme. But again, with the state brief scheme, I can go on and I'm chair of the monitoring committee of the state-funded legal. And if I can tell you the issues we found on ground, suspects are saying the lawyers will say brief, they don't give them sufficient time. Suspects are saying the brief needed the brief again because they never understood. Suspects are saying when they are in court, they only see the lawyers while in court, for instance. The case is beginning today, and then that's when you see the lawyer. The lawyer don't have sufficient sense to visit the suspects there. Of course, efforts are being made to improve the state-funded scheme, state scheme, but still you will find that those people who get state-funded representation are the poor, who cannot afford to go into the chambers of the criminal expert, lawyer to represent them. So that issue is a serious issue of legal representation. So, legal aid provision as a tool for access to justice, and how important we need to invest in legal aid and pro bono. With the above state of affairs, legal aid services, both primary and secondary in nature, continue to bridge the gap towards enhancing access to justice. Some of them may not understand when I say primary and secondary. Primary is the reality where the lawyers who are paid, say here in the Uganda Law Society will project, lawyers in FIDA, lawyers in UCLA, and other LASPs, they are given salaries and they are able to litigate the case wherever the average party feel, including up to the Supreme Court. But primary is the empowerment, where we use a lot of paralegals, where we use a lot of community sensitization. That is also very important because it prevents occurrence of cases. Therefore, under harassment, through our members, the organizations are 60 in number. But on the ground, you ask me a question, are they there? And I'm yet to come to that. I'll play a critical role in providing services to the poor and vulnerable. Sometimes they are thematic based. You find that FIDA is thematic based. Women, children. You're going to start enough or categories of the poor, vulnerable, and marginalized. You find that if you go to them, land and equity movement, it is on the mainly land rights. When you go to Hiraf will tell you we focus on all the issues, but focusing on human rights. So you find that it is in piecemeal, but it is there. We have the comprehensive state-funded legal aid scheme, and the legal aid bill 2022 is still in the legal and parliamentary committee and has not reverted back to Parliament. But we have invested millions of money. We have invested a lot of time in advocating for this law. Since the time of BBF, The formation of the committee to remove the policy. And since 2000, we have been in there. The Vice President has mentioned that in East Africa, we are the only one remaining. Tanzania learned from us and they made the enough to there. Kenya is ahead. Rwanda has a policy. Yeah, so Uganda, we always say we don't have the resources, but we think the resources, if we prioritize the 80% Ugandans, we can get it slow. And if it will improve them, it has a cost socio-economic benefit. We've done research, I can't go into all that, but we have a research on the cost benefit analysis of providing legal aid to those who cannot afford. Using the means and merits, not everyone can access. But when you use the means and merits, it is very important to improve and remove people from poverty using the law as a tool. And if before you know it, the lawyers that only have a 20% access, their clientele will also increase because we have improved. Those who are not able to go to the services, they go into businesses, SME, eventually they will improve, they will acquire land, and before you know it, the clientele of the lawyers will increase by improving access to justice for the most vulnerable. I will end it there when I'm talking about the law, so that I don't go much into detail. The other bigger issue that the last are facing is the donor funding. Those donors that I've mentioned, all the organizations, they are all funded under the University Fund, the Democratic Governance Facility. And when DKF exited, there's no more being given to the legal aid service providers for them to go and get the contest of reason for them to represent. And now you say the research. Therefore, many have closed and many have stayed down. Remember, the prison condition currently stands at 78,819 as of August 2025. Just yesterday, I was with the in-charge remand, and he said the population of the children, and remember the children under the Children's Act are mandated to be represented in any matter. A child is supposed to go with a lawyer plus a probation officer. The child is being there's an inquiry. The probation officer should be there. But no child should appear before a judicial officer without the representation. But as of yesterday, just in Mandimon, here in Mandimon, I've not talked about the rest, 250 children beyond the capacity. Now multiply across the country. As I have already said, the level of legal aid services has tangible benefits to the country's social, economic development, through promotion of rule of law, human rights, social cohesion, peace and security, as well as providing employment opportunities. Ultimately, legal aid is a cornerstone for realization of Sustainable Goal 16 and inclusive development, leaving no one behind. As for suffering, they are grappling. What about us at last? Remember, we are the coordinator. And the coordinator, we give the pace because of our mandate. Our mandate is research, knowledge management. Our mandate is lobbying and advocacy. Our mandate is strengthening institutions, capacity building, peer review, and setting standards, among others. But right now, as we speak, the same way is the network. We can no longer do research. Every year, Mr. President, we used to release the access to justice trends analysis report every year. And this report will be launched by the Justice and the Division. And the recommendations there, they will implement. And we will track them to see how far they've gone. We are seeing the techniques. We are seeing the anti-corruption strategies. We are seeing many changes in the divisions. Some of them, most of them were recommended in our reports. We used to do corruption monitoring.
Sponsors, because the list of sponsors is a cocktail, as has been said. We are going to be rubbing shoulders with UHRC. We're going to be rubbing shoulders with the LDC, the High Court, Uganda Kingdom, and all other associations and law firms, as has been said. Ladies and gentlemen, lawyers, the public, and everybody else concerned about access to justice, kindly kindly take heed and follow up on this call, because at the end of the day, we're extending justice to that very loved one of yours who is within the 80% that is vulnerable, indigent, and can't afford legal aid services. This is the opportunity, and Uganda Society is very proud to associate with the Last Net, and in that regard, we'd like to thank the team that has come as representation of Last Net, especially through the doctor who has elaborated everything that would have been wanted to be had by the members. So ladies and gentlemen, those present physically and those online, thank you so much, and may God bless you as we look to support the cause that has just been asked into. We are going to take a